All right, welcome back. I hope that music was everything that you wanted it to be. It was for me, at least. So we are now moving on to our next event. And for those who did not join us for the first two, welcome. Just a few housekeeping. We are doing questions and answers during these sessions that you can submit at any time at the bottom of your screen. But just to note, we are going to hold having our presenters answer them just due to the nature of online webinars. So next, we are joined by Amanda Johnston from Gardner Law. Amanda specializes in counseling medical technology and pharmaceutical companies on FDA law, regulatory submissions, and and strategy, healthcare compliance programs, and fraud and abuse laws. Prior to practicing at Gardner Law, she was the compliance officer at Coloplast Corporation. She was in regulatory affairs at Medtronic and in compliance at United Health Group. Amanda is also an adjunct professor of law at Mitchell-Hamlin School of Law, where she teaches drug and device law. Thanks for joining us today, and take it away, Amanda.
All right, thank you very much. I think, oops, I went ahead a little bit. But yeah, hopefully, thanks for joining everyone for the webinar today. Hopefully you're enjoying it. I know it's been really interesting just listening. Hearing from Mark and Dulcie and Sarah and Brent, a little bit about kind of the cases that we're seeing, the enforcement trends. And now we're going to talk a little bit more kind of logistics about a compliance program for companies so that we are mitigating those risks that we talked about. So let me see, I missed the slide here, sorry. There we go. So a lot of clients come to us when they're, just starting out, they have a product, they hear they need a compliance program. And a lot of people find it hard to define exactly what a compliance program is. So it definitely is more than just some policies and procedures that you write down and put in a notebook and put on your shelf. It really is a structure. It's an infrastructure, and it consists of rules, so compliance standards. There has to be some consequences or teeth behind those rules. It's the culture, it's the staff, it is a training program, and it's really something that continues to be maintained throughout the company's life. And Sandra will talk a little bit more about kind of maintaining a compliance program. But it also includes response protocols. So really the goal of a compliance program is preventing misconduct. We want to reduce risk for the company, the employees, and our customers, but we also want to reduce incidences of noncompliance, detect noncompliance faster when it does happen, and then take action to prevent it from happening again. So again, it's not just policies and procedures, but of course, that's a big piece of it as well. If you think about it, drug and device companies are subject to so many different complex laws. We heard about FCA, FDA, AKS, Sunshine, the alphabet soup. Compliance is just not going to happen by chance. So it really has to be a deliberate, intentional act when you're setting up your company and building the culture to really be a culture of compliance. So why do you need a compliance program? So I guess first off, I will say that really it is an expectation from the government that any company that's in the medical device or drug space, they're expecting you to have a compliance program. On top of that, many state laws actually require it. So there's several states, depending on whether you're in the drug or device space. There are states that actually require your company to have a compliance program if you're selling in that state. Again, it's strongly recommended. I would go further and say that it is an expectation to do business in this area for lots of reasons. So if you are actually participating in federal healthcare programs, so if you are billing, if that's your business model, it is required under the Patient Protection and Affordable Care Act. So having a compliance program is a requirement if you are actually participating. Generally it shows good corporate citizenship, being an ethical company and having a kind of a mission and a values related to being ethical really does carry weight with the public, with regulators, especially customers, investors. So having that story and incorporating that culture of compliance into really embedding into the business does carry a lot of weight in the industry. It enhances your reputation, your public image. And above that, it also empowers employees to really ask questions, think critically, voice concerns. Some of this, may result in investigations, which we'll talk about, which are normal. But we do want our staff to be aware that that the company is committed to being compliant, and that we want employees to ask questions and bring up issues that they see, because then we can take action and fix them. It also reduces employee misconduct. So I think Sarah had mentioned, the more you train employees and vocalize that you are looking at these things, that they will course correct on their own eventually. And that's kind of the goal. But also proactive detection and mitigation of misconduct. And Mark and Dulcie talked a lot about, and Sarah and Brent, about some of the cases that we've seen with the really high dollar amounts. So another, obvious reason to have an effective compliance program is to really reduce those exposures to civil damages, monetary penalties, criminal sanctions, exclusion, the death penalty of the business. And then, of course, whistleblower lawsuits. So we've seen that those have become quite prevalent, and almost every case we talked about was related to whistleblower actions. CIAs, obviously, those are not fun to go through. But essentially just having an effective compliance program. So the US sentencing guidelines talks about what can be done, or how the company can reduce their culpability score. And so if you have an effective compliance program and you can demonstrate that it is effective, you may get a little bit more leniency when it comes to settling or enforcement activity. All right, so I think everybody probably is aware of the OIG's 7 elements of an effective compliance program. So the OIG's published several guidances on compliance program structure and kind of what they expect to see. There is one specifically for pharmaceutical companies, which also applies to medical devices and any other products that are reimbursed federally. But I'll go through these pretty quickly, and then we're going to focus kind of on investigations, which relates to elements 6 and 7. So implementing written policies and procedures and a code of conduct or standard of conduct. Obviously, as I mentioned at the beginning, compliance program is more than just written policies and procedures. You actually have to implement them, deploy them, use them, and then continue to modify as needed. So there's some key policies that you'll want to take note of at the beginning. I'll touch on that in a minute. Of course, designating a compliance officer, so someone who is the focus of the compliance program at the company, whether that is a full-time, compliance officer or somebody in quality or internal audit that wears the compliance officer hat kind of in the interim. You could also engage an outside consultant or outside counsel to act as your compliance officer, but really having somebody that their focus is on compliance, that's critical. And then, of course, impaneling a compliance committee. So that would be, a panel of usually representatives from various functions that meets regularly to actually oversee and help the compliance officer with the implementation of the program and any issues that come up and taking action to correct those issues. Conducting effective training and education. So the government really would like to see an annual training program where, sales staff and anyone who has interactions with healthcare professionals receives healthcare compliance training at the time of hire, along with annual refresher training or ad hoc training as needed. There may be times when an issue arises or a question comes from the field and you'll want to go back and kind of do a refresher training. But they want to see that you have a cadence, that there is a program that's built, and that you're continually reviewing and addressing any changes that need to be made. Kind of looking back to the cases that we talked about. So thinking about the trends, maybe you want to retrain on speaker programs or, provide a little bit more detailed information for the sales staff that's involved in speaker programs. The government would want to see that. Number 4 is developing effective lines of communication. So this is kind of, relating to having a visible compliance officer, having an open door policy where anybody can go and ask questions, sharing the identity of the compliance officer, obviously, so that employees and staff know where to go when they have questions. That's important because, if a question comes up in the field and they don't know who to ask, they may just decide on their own to without seeking input. This also applies to a compliance hotline or compliance reporting system, which we'll talk about in a few minutes here, where there's a method or manner to report compliance questions or concerns or allegations that they may choose to report anonymously. So it's important to have that open door communication policy with the compliance officer. Conducting internal monitoring and auditing. So we talked about that a little bit already, but essentially having a program that's documented and followed for auditing. So regular auditing, there are some states that require you to attest annually that you completed your compliance audits. And then monitoring is really a lot of the day-to-day compliance stuff. So it's answering questions, it's checking expense reports, it's just kind of the day-to-day ongoing work that you will do as you're really monitoring the compliance program. And then 6 and 7 relate to, of course, we have policies and procedures, and there are standards and disciplinary actions that would be taken if those policies or compliance standards are violated. So that's important because it shows that there are teeth behind the rules and that they will be enforced consistently and through guidelines that are set in advance. And then responding promptly to detected offenses and undertaking corrective action. So this really relates to the investigations topic, which we'll talk about, but essentially, if you become aware of an issue, take prompt action to look into it, determine if an investigation needs to be done, and then follow the investigation through to completion and take corrective action that needs to be taken in accordance with the outcome of the investigation. All right, so a lot of our clients will come to us and they will, we go through the process of explaining what a compliance program is, why you need it. They see the list of the 7 elements and they're like, oh my gosh, that's a lot. Where do I start? I can't do everything at once. So I tried to distill down to kind of 10 categories, I suppose, that you could say to think about. And this is not necessarily in order, but it's just kind of thinking about how I would approach building a compliance program. So really the first step is really understanding your business model, your product, what industry you're in, your sales practices, and identifying the key risk areas. So understanding all the laws that apply, all the regulations. So whether it's FDA, FCA, AKS, thinking about sunshine possibly into the future if it's a new product, but really having somebody, whether it's internal or hiring somebody outside, to help you get a lay of the land from a compliance and legal risk perspective, because that's going to really drive a lot of your activity later. And then number 2, designating a compliance officer. So again, you can utilize outside counsel for this. You can hire a consultant. You can use an existing employee, even if it's somebody who's taking the role on a part-time basis for the beginning, and then building out a compliance committee. And usually it's, when a company's starting out, it's a small company. And so it's pretty easy to designate who should be on the compliance committee. And that can always change as the company grows and matures. Number 3, I have complete a compliance assessment or a gap assessment. So what I would recommend is really sitting down with the 7 elements of an effective compliance program, using that kind of as a guide to begin. It'd probably be a compliance committee meeting where this is done, or the compliance officer would do it, and really kind of going through the checklist. What do we need to do? What can we kind of hit easy kind of at the beginning? And what's going to be a short or long-term goal for the compliance program? And that really all of this should be driven by the risk areas that apply in your business. And then implementing the key policies and procedures. So that's, drafting them, whether it's hiring somebody to help you draft them or to get templates as a starting point, but really based on, again, the number one on the slide, based on the laws and regulations that apply and your business practices, what policies and procedures do you want to put in place now? And then establishing kind of a rolling out cadence, because we find that it doesn't work necessarily as well when you implement, 15 policies at one time and then just roll them out and everybody signs them and agrees, but rather kind of having a cadence based on priority and risk, and then doing trainings and kind of having a cadence to roll those out can be more effective. All right. And we talked about culture a little bit already, and I think Sandra will talk about it a little bit more. But really embedding yourself within the business is something you want to start very early on. A lot of people joke about compliance being the sales prevention team, and you want to kind of prevent that by collaborating early on with stakeholders, building those partnerships so that they will come to you for guidance or questions early on when they're coming up with new programs, or if they have questions, so that you're not having to be the no man at the end of once they're trying to roll out a program. So really it's building trust. There's a lot of kind of interpersonal relationship concepts at play here, and so it's just kind of building those relationships, building trust, and then helping to meet the goals of the sales and marketing team and the business team while staying within the bounds of what of the law and what the company accepts from a risk tolerance perspective. And then developing training programs. So this should be kind of done as you're rolling out the policies and procedures. It kind of makes sense that you'll roll out a policy, you'll have training of some sort, whether it's live training, which obviously these days is more difficult. But in my past, I had done a live training with every new sales rep. And it was like a monthly or bi-monthly training, and I actually really loved it. It's a great chance to meet face-to-face, hand out a card so that they can contact me if they have questions. There's a lot of value in that live training, but it is difficult obviously to do these days, and just as more reps and staff are kind of scattered throughout the country. But I think Sarah had mentioned at like the NSMs, so that's a really good opportunity to be there, mingle, talk to people, and kind of just be visible. So for training, live training, if that's not an option for you, at least not for every new hire, you could do recorded videos, you could do webinars. I mean, a Zoom meeting like this, where at least you're having the face-to-face somewhat contact, and you're able to really kind of talk to them, get to know them, and then they have, having them be comfortable with you so that they'll come to you with questions, of course. And there's also e-learning. There's tons of great e-learning systems that you can utilize kind of in conjunction with any live or webinar training. And then thinking about kind of a compliance communications plan. A lot of companies that I've been part of, they'll have kind of a monthly theme that I really enjoy, that you can kind of have a regular cadence of a communication plan. So, you'll get an email with a video and kind of a little quiz every month based on the topic, and that you can adjust those topics based on, what are the hot industry trends? Maybe it's speaker programs. So kind of focusing on those things. And it's kind of a fun, interactive way to continue that compliance conversation without having to sit and have a live training, so that it doesn't, feel so much like a training, but really just having that communication open door policy. And then the hotline. So that's kind of an easy one to get checked off early on. A lot of companies will start with like an email box, obviously not ideal in the sense that you may not be able to report anonymously, but it might be a good option for those just starting out who are, still looking into, some sort of a vendor or a voicemail line that they could use. There's lots of vendors out there that have online reporting capabilities, and you can also call in. So I'd encourage you to look into those. And then as you kind of develop, initially, you'll probably just have one compliance officer or even a part-time compliance officer, but thinking towards defining the budget, and headcount needs. And this will obviously evolve as the company evolves, and will, of course, the enforcement environment will affect that as well. And Sandra will talk more about maintaining the compliance program, but you never are really done with the compliance program. It's a continual, it's continuously adapting, we're modifying, we're making changes, there's policies and procedure changes that are kind of ongoing. So it is something that you can set up, but it's never really complete because it's a journey, it's a compliance journey. All right, and we talked a little bit, I think it was Sarah and Brent that talked a little bit about culture. I mean, of course, this is a big piece of it. We want to promote a culture of compliance. This starts with senior leadership. We want them to, give lip service to compliance, starting maybe, town halls with the slide on compliance, or their commitment to compliance, or ending calls, ending business meetings with a reminder of the code of conduct. Really just promoting shared responsibility and a commitment to compliance, and also holding, their direct reports accountable for compliance, so that it's not just, the staff, it is everybody throughout the organization that has accountability for compliance. Compliance function, of course, should be visible. All right, so we talked a little bit about kind of the logistics and steps with setting up a compliance program. And now we're going to focus a little bit more on performing investigations. So these are internal investigations. I think Dulcie will talk a little bit more about enforcement investigation, but this is focusing more on internal investigations. And a lot of people get a little nervous when they're thinking about investigations because it's kind of a scary word. But they're kind of fun. You get to put your detective hat on a little bit, but essentially, I would just say they're normal, they're common, they will happen. So you want to be prepared for them. And the government would expect you to, you're going to get triggers, some trigger events that will require an investigation. And so you want to be prepared and have a policy, a process before you need it, just so you're not scrambling to try to figure out what to do. So kind of just at a high level, again, you want to be prepared before you need a policy on investigations. And it doesn't have to be like incredibly detailed down to names and time, it doesn't have to be incredibly detailed, but at least having a general idea of what will happen if we get a trigger that requires an investigation. What does the process look like? What do we need to document? Who's involved? So a lot of people assume that really investigations are triggered only by hotline reports, which a lot of them are, but really investigations could be triggered by any number of things or communications. So it could be something you heard in a meeting or in a hallway conversation, a report, obviously. An enforcement agency may contact you. It may be an audit finding, whether internal or if it's an FDA finding, routine monitoring, if you're looking through expense reports and you notice something that that flags your attention, that could trigger, it could essentially trigger an investigation. A lawsuit may be brought. You could get a complaint, whether from a customer or a patient or a competitor even. So just kind of keep in mind that the scope of what could trigger an investigation is broader than just the hotline. All right, so then initiating the report. So really the first thing I do, so we'll kind of pretend that we get a report through our hotline and it's in writing and it's anonymous. So first thing we want to do is really read it, understand it, kind of parse it out, then look at kind of figure out what the issues or what the allegations are. So look at, is it a known observation? Is it a repeat issue? Have you done training on this recently? And that's what maybe prompted the question. What is the risk level? Are we looking at, a policy violation or a process violation, or are we looking at more of a potentially criminal issue? Are there industry trends? Is it related to speaker programs, for example, or recent prosecutions or settlements that touched on it? You can assess the credibility initially, how it's written. Does it seem to be credible? Are they using inflammatory language that appears to be targeting a certain person? These are all things you'll want to just kind of think about as you're conducting the initial assessment. And if you have the identity, most of them I'd say are anonymous, but not all. Some will provide their name. But if it is, if you do have the name, figure out, is it an employee? Who is it? How long have they been there? What function are they in? And then just lastly, are they making allegations that would prompt us to stop or start doing anything right now, or pause while we are investigating? So again, that kind of goes back to the nature of the allegation, and it will obviously be different decision for each report that's investigated. All right, so who should investigate? So most companies want to try to keep their investigations under attorney-client privilege or work product privilege, understandably. I'd encourage you to kind of consider that before you initiate the investigation, just to make sure that you're in a good spot in terms of cementing any privileges. Involve counsel, whether it's in-house or outside, at the very beginning. So like the minute you get the report, the compliance officer if should be contacting counsel to potentially initiate an investigation. But it's key to have an investigation be conducted at the direction of and under the supervision of a lawyer for the purpose of obtaining legal advice. And so that's critical. It can't be business advice. It should be legal advice as the significant purpose. And again, communication should be kept totally confidential related to the investigation. There may be some considerations for using outside counsel for investigations. There may be, depending on the allegation, there may be conflicts, bias. There may be sensitive issues or individuals kind of called out in the allegation. Also, some companies just don't have the time, the resources, the capabilities to conduct an investigation. I know I've conducted many for clients, and it's just a matter of, just not having the time to dedicate to it, or having somebody who's more independent, which is really valuable. You may consider engaging outside experts or consultants, and you'll want to think about how you do that to preserve privilege if that comes up. Carefully scoping the investigation so that it's not too broad, but it's also not too narrow, such that you'll miss, some tangential issue. All right. And then assembling the investigations team. So of course, depending on the allegation, it should be a small team, obviously, just who needs to be involved, but depending on the nature of the allegation, it may vary. So there may be HR, legal, maybe finance, obviously keeping them in kind of the scope of the privilege. All right. So once you have kind of the complaints assessed, you have the team situated, you're performing an investigation at the direction of an attorney for the purpose of obtaining legal advice, you'll want to start diving into the documents. And so this sometimes can be a process, depending on the allegation, of course. You'll want to start requesting records from your business partners, whether it's email keyword searches, whether it's sales reports, sales data, trending. There may be, documents, there may be sign-in sheets or expense reports. A lot of them seem to involve expense reports, which is tedious work, but it actually is very informative because you can kind of dig through and map out kind of a calendar of when expenses were incurred on certain dates to kind of get deep into the weeds on the details. You may use internet searching. I have used social media on many occasions in investigations. Just when certain people are named and you're looking kind of for background information, it is helpful. Obviously not relying on their social media posts, but just getting as much information as you can about those that are involved in the investigation is helpful. Especially if it's like a specific doctor or a practice, you can do some research on the history of that practice, see if there's been any issues in the past, that kind of thing. In some cases, you may need to get kind of expert help from a document review or financial review perspective. So just keep in mind that you may opt to hire a computer forensics expert or a financial auditor if the need arises and if the risk level is such that becomes necessary. All right, so you've assessed your report, you've done all the document review that you can, which actually it's tedious again, and it does take a lot of time. I don't want to downplay that, but there will be a point where you will want to start talking to people. So typically, if you have the name of the reporter, that would be, one of the first people that you speak with, but not always. And as you're going through the document review, you'll want to note down kind of names of who you'll want to talk to at the company, and then consider always interviewing their manager or people that they work with as well. But the list will likely change or grow as you proceed with your investigation. So also consider the order of interviews. So, you may choose not to interview the reporter first. Maybe you want to interview somebody else, just based on the strategy of what you want to ask and how you want to go about the interview. So prepare specific questions, be clear on how you want to ask them. When you're talking to them, you want to be clear on who the client is, consider the upjohn warnings. You want to be clear that you are not their counsel, that they have the ability to obtain their own counsel. These are all just very important key aspects of speaking with an interviewee. And I know we're at time, so I think I have just a couple more slides I'll go through quickly. So we talked about this already, but just making sure that you're very careful with your communications and documentation, marking everything as privileged. Again, noting in the documents that there was counsel involvement and you've initiated the investigation to obtain legal advice. Typically, there's some sort of a final report or memorandum that's prepared, and then we will talk briefly about reporting out. So you get to the end, you have a report, you're going to have to share it with people that need to know the information. So that's typically not, the entire senior staff. It is typically the executive team or a very small, a number of executive team members or the board. This will vary based on the nature of the allegation. Just consider timing, method, the manner, the audience, privilege considerations, confidentiality. We want to protect the reporter. So, not disclosing the name of the reporter in the report out is a good practice. And reports are not always substantiated, but there may be times where the report may not be substantiated, but you still want to take corrective actions or mitigating measures just to kind of prevent issues that come up in the future. All right. And my last slide is just thinking about things that may happen after an investigation. So you decide to take corrective action. It could be disciplinary, it could be repayment, it could be disclosure, whether voluntary or mandatory. You'll want to involve SEC counsel if you need to, of course, prior to disclosing to investors or public, if that's applicable. You may just update compliance training, do retraining, updating policies and procedures. And then also, just depending on the nature of the allegation, of course, and the risk level, consider whether and when to engage somebody that could help with white collar crime defense. All right, and that is all I have. Sorry, I ran a little bit late here. I'll pass it back to you, Mary.
Thanks, and thanks for wrapping that up, Amanda, but you've got good stuff, so we wanted to hear it too.